5 seconds. In case there is any non-compliance with form number 3, the same is a mere irregularity. In case the affidavit is found to be defective on account of non-compliance with form number 3, then opportunity should be given to rectify the defect. Reliance in this regard is placed on the decision of the Apex Court in Malhotra Steel Syndicate versus Punjab Semi Plants Limited, 1993, Supreme Court cases 565. In view of the aforementioned Supreme Court decision in Malhotra Steel Syndicate versus Punjab Semi Plants Limited case, Supra, overruling the division bench decision of the Punjab and Haryana High Court, the decision of the learned single judge of the Punjab and Haryana High Court in Mool Chand Bhai case, Supra, as well as the decision of the division bench of the Punjab and Haryana High Court in Mool Chand Bhai case, Supra, relied upon by the learned counsel for the respondent company stood overruled. It is pointed out that the learned single judge of the Punjab and Haryana High Court in Mool Chand Bhai case, Supra, followed the said decision of the Calcutta High Court in Gaya Textile case, Supra. Reference is further made to the decision of the learned single judge of the Punjab and Haryana High Court in Malhotra Steel Syndicate versus Punjab Chemical Plant Limited, 1989-65, Company Cases 546 P and H, which was challenged before the division bench of the Punjab and Haryana High Court against the decision of the division bench of the Punjab and Haryana High Court. Appeal was filed before the Supreme Court, which was decided by the Supreme Court by its aforementioned decision reported in 1993 Super 3 SSC 565. Emphasis supplied. Having laid down the above proposition, the learned single judge of the Punjab and Haryana High Court dismissed the winding up petition on the ground that it was not accompanied by a proper affidavit. Against the said decision of the learned single judge of the Punjab and Haryana High Court, Company appeals under Section 483 of the Companies Act 1956 was filed before the said High Court. A division bench of the Punjab and Haryana High Court dismissed the said company appeal by its decision reported in Mool Chand Bhai versus National Paint Private Limited and ANR 1986 60 Company Cases 402 P and H, Supra. The division bench of the Punjab and Haryana High Court rejected the submission made on behalf of the petitioner appellant that he should have been allowed to file a fresh affidavit in support of the company petition and upheld the said decision of the learned single judge of the Punjab and Haryana High Court. The division bench of the Punjab and Haryana High Court held as under 8 pages 403-404 of the said company cases. The company petition was accompanied by an affidavit dated February 20, 1980, which was not in proper form. In its verification clause, paras 1 to 14 of the affidavit were mentioned to have been true and correct to the best of the deponent's knowledge and belief. The appellant, in accordance with law was required to specify which paragraphs of the affidavit were correct to the best of his knowledge and which were correct to his belief. Rule 11 of the Companies Court Rules 1959, hereinafter called the rule, defines petitions. A petition under section 439 of the Act for winding up of a company is mentioned in sub rule 15 of the said rule. Rule 21 prescribes that every petition shall be verified by an affidavit made by the petitioner, and such affidavit shall be filed along with the petition and shall be in form number 3, which in turn prescribes that the petitioner shall mention the paragraphs of the petition which are true to his knowledge and the paragraphs which are based on information and he believes them to be true. Rule 18 lays down that every affidavit shall be signed by the deponent and sworn to in the manner prescribed by the Code of Civil Procedure, hereinafter called the Code, or by the rules and practice of the Court Order X1X. Rule 3 of the Code lays down the matters to which the affidavit shall be confined. Mr. Rata also admits that where a petition for winding up is not supported by an affidavit, the same is liable to be dismissed.